Today, we're going to cover Form 21, pages 2 through 5. And I gave you guys homework from last week to read Form 21. Did everyone do it? Lacey, did you do it? Right on. Harry?
Yeah.
Right on. All right. So we're going to go through each and every paragraph of it because hopefully, as you guys read through it, a lot of it made sense and some of it did not. And so today will be a forum to ask those questions to get clarification, right? So let's just dive right in, all right? So paragraph A, purchase price. Buyer shall pay to seller the purchase price, including the earnest money in cash at closing unless otherwise specified in this agreement. How might you otherwise make payment than cash? Financing, right? You get a loan. That's what this is referring to. So the financing addendum is a way to otherwise specify in this agreement. Not a big deal, but I want to drive that point home because as we go through these contracts, you're going to see the MLS has given you the flexibility and the protection at the same time. But there are areas where there's opportunity too. And we want to make sure we know those so that A, we can exploit them if needed, and B, we can shield our client from being exploited if we don't. Okay? Buyer represents that buyer has sufficient funds to close this sale in accordance with this agreement and is not relying on any contingent source of funds, including funds from loans, the sale of other property, gifts, retirement, or future earnings, except to the extent otherwise specified in this agreement. That what should have just popped into your head is, contingent addendum, right? If I want to make an offer contingent on the sale of another property I have, if I don't have that contingency addendum in this agreement, I'm actually prohibited from doing that. How many people do you know, buyers or sellers, that read these cover to cover? Not many. So you got to make sure that you're protecting them. You're the one that's going to say, hey, this house has a septic system. We're going to put a septic addendum in there because we want to make sure that thing gets tested and cleared, right? Your buyer's probably not smart enough or aware enough. I shouldn't imply they're not smart, but they're not aware enough that there are prohibitions against selling a home in this county in particular without getting it tested, but you still want to have it in writing that it's going to be. We'll cover that addendum another time. All right? Paragraph B. This is a big one, right? Not just physically big, but this is a critical one in your role as protecting the client, right? I've never had a client lose their earnest money. And I'm not going to start now, nor should you, right? Buyer shall deliver the earnest money within 2 days after mutual acceptance of this agreement to the selling broker, who will deposit any check to be held by the selling firm, or deliver any earnest money to be held by the closing agent within 3 days of receipt of mutual acceptance, or 3 days of receipt or mutual acceptance, whichever occurs later. That says quite a bit, right? If a client gives me an earnest money check on Monday, but we don't get mutually accepted until Thursday because we're negotiating, when does the clock start ticking on my obligation to deposit?
Mutual agreement.
Whichever occurs later. Exactly. Now in this office, we don't maintain a trust account. So the first section, the 2-day time frame, does not apply to us. And you don't want to be in a position to hold earnest money. So you shouldn't gather a check and sit on it while you're negotiating. Tell your client, you hang on to it. Once we get mutual acceptance, we'll have a courier pick it up from you. And then just let Jackie know. All the title companies we work with will be happy to go get that check at their work or their home. So don't put yourself in a position, or me as your broker, of liability for a lost check. Right? All right. If the earnest money is held by selling firm and is over $10,000, it shall be deposited into an interest-bearing trust account in selling firm's name, provided the buyer completes Form W-9. Interest blah, blah, blah. None of that applies. We don't take any earnest money of any size, right? So it doesn't matter if it's $10,001, we aren't going to deposit it anywhere because we're not going to take it. All right? Any questions on that? Because I'm actually going to speed up and move back down here.
The only thing I would say, having been audited by the state, is that the one time they nailed me on not depositing the funds in a timely manner, and they actually look at that as part of their audit. They look at when were the funds to be received and when was it deposited, and they subtract it out and they nail you.
Yeah.
And
They're enforcing this,
yeah,
right? This whole not the whole contract, but the majority of this contract is born of the rules, the laws, the RCWs, right? That's why it says 3 days. So the minute you hit day 4, the DOL in their audit says, hey, you didn't comply with the law.
and that puts you at risk of DOL getting
Right.
down on your case.
Right.
And the best response to why you were late is brain fart.
The best response to why you're late is don't be late.
With the DOL, that worked real well. He thought it was great.
Yeah, I'm gonna actually just never be late,
Yeah.
right? What happens if you're late right now in our office? Does anyone know? You guys need to sell more houses. If you're late, our quality control system, Matthew, will identify that, and he will tell you to provide an addendum from both buyer and seller that acknowledges that it was deposited late. Do you know why we do that?
Compliance.
And late earnest money voids the contract. Earnest money's late all the time, and those deals still work their way towards closing and close. But either party could have terminated without recourse along the way if they change their mind. So to protect you from that happening, our operations department is going to say, hey, Addie, your earnest money was late. Please get this addendum signed. And he'll actually give you the addendum. And it says, buyer and seller acknowledge that earnest money was deposited late. Both agree to proceed to closing. That removes the flaw in your contract that was triggered by a late earnest money. That closes that gap. Does that make sense? All right. So we're not going to worry about interest bearing. Upon termination of this agreement, a party or the closing agent may deliver a form authorizing the release of earnest money to the other party or the parties. So you can authorize releasing the money to the other party. They can't authorize releasing it to themselves, and nor could you. Does that make sense? If there's a dispute over earnest money, one party or the other is not going to sign that form that says go ahead and release it to the buyer or seller, whatever it is. At that point, escrow has the option to interplead it. Has anyone heard that term before? So interpleading means escrow saying, hey, I have two parties that can't agree. Let's let them fight this out in court. And they submit an interpleader, and the courts give you a day and time to come argue your case, and the judge will decide who gets the earnest money. And that happens, you know, more often than probably escrow would like. But that's the process, right? Party shall execute such form and deliver the same to the closing agent. If either party fails to execute the release form, the other party may make written demand to the closing agent for the earnest money. If only one party makes such a demand, closing agent shall promptly deliver notice of the demand to the other party. If the other party does not object to the demand within 10 days of closing agent's notice, closing agent shall disperse the earnest money to the party making the demand. That's an important one for you, because what that's saying is if you guys can't agree, buyer and seller can't agree, and you submit your notice to escrow saying, hey, we want it, and then they don't respond for 10 days, you won. You get the money. Your client, I should say, gets their money back, right? Conversely, if you're representing the party that's receiving the demand, remember this, because you better respond, or they're gonna give the earnest money to the other party. Does that make sense? All right. If closing agent complies with the preceding process, each party shall be deemed to have released closing agent from any and all claims or liability related to the dispersal of earnest money. That's a cover my butt for escrow. Because if they didn't say that, the party that did not reply in those 10 days could say, hey, escrow, you're on the hook for the earnest money. Give it back out of your pocket because I didn't authorize you to release it. Okay? Parties are advised that, notwithstanding the foregoing, closing agent may require the parties to execute a separate agreement before dispersing the earnest money. If either party fails to authorize the release of the earnest money to the other party when required to do so under this agreement, that party shall be in a breach of this agreement. Upon either party's request, the party holding the earnest money shall commence an interpleader action in the county in which the property is located. For the purposes of this section, the term closing agent includes the selling firm holding the earnest money. Parties authorize the party commencing an interpleader action to deduct up to $500 for the cost thereof. That makes perfect sense to me and might sound like legalese to many of you. So I want to pause here long enough to answer questions. I described the interpleader action a moment ago. That's what that's referring to. Okay? And what they're saying is escrow, if they have to prepare paperwork to file it, they can charge $500 for that work. Shouldn't cost that much, but how much you want to bet they all collect $500? Is everyone clear on earnest money? And we're not going to go through all the way through to paragraph X in this level of detail, but earnest money is really, really critical. We as a firm don't ever want to lose somebody's earnest money. Okay? All right. So your silence means you've got it locked in. Is that true? No? Abby's shaking her head. You have a question, or are you just nervous?
Well, just that didn't make any sense to me, and I really need it interpreted.
So what your homework from today, I want you to write this down,
Okay.
is read the Form 21 again, make notes on it, and then set a time to meet with me. And we'll go through your questions and your notes, okay? Because I want you to know it really, really well, and it's not normal language, right? The entire contract is legalese. That's why we're doing this, because I'm going to do my best to distill it into language you can understand. The risk of doing that is altering its meaning. So there's definitely portions of it where I'm not going to change a word. You noticed I didn't paraphrase much of that paragraph, right? Because earnest money, they try and make it as clear as possible so that it's a black and white issue. And then they address, well, what if it's gray? What if people disagree? Well, punt, right? Punt it to the courts. Okay? All right. Included items. This is a big one that comes up a lot, right? This is about, hey, what do I get with the house? Do I get the drapes? You know, how many REO have you seen where the range was stolen or whatever? So there's built-in language that says any of the items, including items identified in specific term number 5. Where's that? Specific term number 5.
The lines that on the first page where
First page.
check things off.
Lacey's got it right there. Line number 5 is the one where you check stove/range, dishwasher, washer, dryer, right? Satellite dish. Right. So all of the following items, including those identified in number 5, if the corresponding box is checked, located in or on the property, are included in the sale. Built-in appliances, wall-to-wall carpeting, curtains, drapes, and other window treatments. Have you ever sold a house, had your client call you the day they moved in and said, where'd all the drapes go? Seller took them with them. Or, conversely, have you ever shown a property where there's a little postcard on the wall that says, drapes go with seller? That's why they're doing that. They're disclosing up front, hey, before you make your offer, I'm telling you I'm keeping the drapes. I had a deal where the seller didn't disclose that they wanted to keep the drapes, got a full price offer, and said, I want to remove the drapes. And I said, you really should have told me that before, because now you have a buyer that's willing to pay full price. They want the drapes. Buyer wouldn't budge, seller wouldn't budge, didn't close. Not only that, I got fired over it. It wasn't my mistake, right? We walked the house. I marked other things, but they never said anything about the drapes. So communicate at a very high level with your client. Understand this paragraph because they have made certain representations just by virtue of listing it, unless you make disclosures to the contrary. Okay.
In your transaction, did you wind up earning a commission because you had brought a buyer ready, willing, and able to pay?
I was a listing broker, but yeah, I could argue that.
Okay.
But I'm not in the habit of suing homeowners.
No.
And nor should you be. Does that mean we should get walked over? Absolutely not. But as a brokerage, we don't want to be known in the marketplace as that firm that's so hell-bent on defending its rights that it sues consumers, right? Okay, wall-to-wall carpeting, window treatments, window and door screens, awnings, storm doors, and windows, installed TV antennas, ventilating, air conditioning and heating fixtures, trash compactor, fireplace doors, gas logs and gas log lighters, irrigation fixtures, electric garage door openers, water heaters, installed electric fixtures, lighting fixtures, shrubs, plants, and trees planted in the ground, other fixtures, all associated operating remote controls. If any of the above included items are leased or encumbered, seller shall acquire and clear title at or before closing. That was a lot. Have you ever heard of a water heater being leased? Right? If I lease my water heater from Puget Sound Energy and I don't disclose that, I have to acquire and clear title at or before closing. I got to give Puget Sound Energy $1,200 so you can have my water heater. That's messed up, right? That's why there's other parts of the agreement where you indicate, yes, this is leased. I'm now disclosing that it's leased, right? Form 22D, which we'll cover in detail, is it has a place where you disclose anything that's leased. Okay? Questions on fixtures?
I just thought you had to buy a water heater. You had to pay for it if you were selling. You couldn't sell it as a leased.
No, a buyer can take over the lease.
Okay.
Maybe that's a change from your last
Yeah.
term through. Condition of title. What do you care about as a buyer's agent or a buyer about title?
Everything.
Everything, that's right. Really boils down to one thing though, right? It better be marketable title. That means I'm buying it, it's clear of any encumbrances, clouds, or other problems. If you got a bunch of issues, Mr. Seller, that's fine, but I'm taking for granted they're going to be cleared up at closing. Your mortgages get paid off, your judgments and liens and whatever else, right? Unless otherwise specified, title of the property shall be marketable at closing. Okay? Following shall not cause the title to be unmarketable. Rights, reservations, covenants, conditions, and restrictions presently of record and general to the area. Easement and encroachments not materially affecting the value. So if you get a title report and you find out there's an easement along it, can you claim that's unmarketable title?
No.
No. Could you
There's a lot of easements that are recorded.
You could terminate if you had a title contingency. Because you're not saying, I'm terminating because it's unmarketable title. You're terminating because it's unacceptable to you. Maybe you don't want that easement. right? Most properties have had easements for decades and have changed hands multiple times. You couldn't even just looking at it tell that, oh, that driveway is actually on my land. It just looks like a flag lot for the home in the back, right? But it's important to know what the buyer's rights are, right? Monetary encumbrances or liens not assumed by buyer shall be paid or discharged by the seller on and before closing. Title shall be conveyed by a statutory warranty deed. If this agreement is for conveyance of a buyer's interest in a real estate contract, the statutory warranty deed shall include a buyer's assignment of the contract sufficient to convey after acquired title. What does that mean? If I want to buy Dick's house in Normandy Park because it's awesome, he can sell it to me on a real estate contract. If I don't record that contract, title is still in his name. But I can sell my real estate contract to Diane. Title's still in Dick's name. My position is a little precarious, right? I mean, I've got an enforceable agreement, but there's, all he has to do is say, I don't agree with it. Now I got a fight on my hands. I'll probably win, but I'll have to spend money on an attorney.
But in the meantime, I will have sold it again.
That's where it really gets messy, right? And my point being, if I sold it to Diane, if I'm precarious, she's even more precarious, right? Unless we agreed up front about the transition of those obligations, right? That's all those last couple sentences mean. A buyer's interest in a real estate contract, the statutory warranty deed shall include a buyer's assignment of the contract sufficient to convey after acquired title. So that means once we get Dick's house put into Diane's name, that deed gets perfected and she now has marketable title. Make sense?
Are they referring the contract to a deed of trust? I thought they went out real estate contracts.
They're still around.
Are they?
Yeah. I have a deal right now. Has anyone noticed on the board I have a closing scheduled for November of 2014? I wrote that deal two years ago. Yeah, it was a 3-year contract.
But does anybody use it? Because the foreclosure procedure is
What
about
am I,
a year
nobody?
long. Huh?
Deeds of trust are far more common. The statutory warranty deed is not the same kind of deed that Harry's asking about, right? The statutory warranty deed is the instrument used to convey title from one party to another, and it has certain obligations of warranty by the seller to the buyer, right? There's a bargain and sale deed, that's a different one, has no warranties. That's a deed more commonly used by a bank because they've never occupied, lived in, owned until it's foreclosure. They don't want to make any warranties about the house. So they use a bargain and sale deed, or there's other types as well. So, gets back to the first sentence, right? All we care about is marketable title at closing. A lot of stuff can lead into it, but it better be marketable by the time we get to the end. Yes, ma'am?
So whose responsibility is it to make sure that everything happens correctly in that section? Is it the title company?
Exactly.
Okay.
Yeah, that's why you buy title insurance. Because if they didn't do it correctly, that's when the insurance kicks in. Right? If I bought Lacey's house and didn't know at the time that my neighbor's shed was partially on my lot and he wanted to claim adverse possession for the open and obvious use of that land for a period of time, I think it's 10 years. If title didn't pick up on that, I could go back to them and say, you need to work this out. I'm not giving him my land, right? So this is fraught with risk. That's why we buy an insurance policy. And it's risk of things that we wouldn't necessarily know how to solve, right? The more you learn, the better equipped you are to steer people on, hey, here's what you need to do. But it's really not you doing it, okay?
is it correct that is it correct that there are two types of title insurance? The statutory warranty deed is maybe a lower level of title insurance as compared to the one where the title company actually goes out and looks at the property, lays it out, and verifies that your person's shed isn't on the other property, and you can get that, but you have to pay more for it. And so, unless I'm getting these backwards.
You're mixing in the statutory warranty deed, which isn't what you're talking about, but you are right. There are different levels of insurance. You can get standard insurance, that's what the contract defaults to. You can ask for extended insurance, oftentimes referred to as Alta Extended Insurance, which triggers a survey. Much more expensive, takes more time, but gives you that comfort. We don't often, in fact rarely, we use that because most neighborhoods are very clearly defined, right? We live in a community that's so prevalent with plats and developments and those sorts of things. You know where your land ends and his starts for the most part. But if you have reason to think that the fence is offline by 2 feet, then you would go buy a survey, and that could be $1,500 to $3,000 depending on how big your land is and how hard it is to survey. We just did a survey for a REO listing in DuPont, and it only cost us about $900. And that's because it was in kind of downtown DuPont, right? So it was all lot and block, is what they call that, and it was easy to survey. All right. Man, this video is not going to be 5 minutes. Title insurance. It's logical that this would be the next paragraph, right? We've talked about condition of title. Next thing up is title insurance. This is what gets into Dick's question, okay? Seller authorizes buyer's lender or closing agent at seller's expense to apply for the then current Alta form of homeowner's policy of title insurance for a 1 to 4 family residence from the title insurance company. Seller authorizes buyer's lender at seller's expense to get a title insurance policy. That's pretty cool. If seller previously received a preliminary commitment from a title insurance company, how often do you see that? In the listing it says title order number 12345, right? That's where this is coming in. From a title insurance company that buyer declines to use, buyer shall pay any cancellation fees owing to the original title insurance company. Otherwise, the party applying for the title insurance shall pay any title cancellation fee in the event such a fee is assessed. If the title insurance company selected by the parties will not issue a policy for the property, the parties agree that the title insurance company shall instead issue the then current Alta standard form owner's policy. Right? Together with the homeowner's additional protection and inflation protection endorsements if available. Whew, that's saying a lot, right? You ever bought life insurance and they're like, oh, you're going to have this endorsement and this rider and this and that, and all you care about is, am I protected? This is legalese telling you and your client what your obligations are for getting title insurance, and if it's not available, what your protection is for getting a lesser policy. Okay? Title insurance company shall send a copy of the preliminary commitment to the seller, listing broker, buyer, and selling broker. Preliminary commitment and the title policy to be issued shall contain no exceptions other than the general exclusions and exceptions in the policy and special exceptions consistent with the condition of title herein provided. Questions on title?
Where things come up, I don't know that I've had this, I just honestly can't remember, but you order the title insurance policy when you take the listing. You put the title insurance number in the multiple listing service, telling the selling agent what title company to use, what all that information is.
Right.
If they would then choose to be, maybe because of a prior relationship or because of an escrow or whatever it is, then they want to use that title company. What this would be saying is, pretty much you can do what you want, but if you want to do that, now you get back to the title insurance company that you selected not being paid for the work that they did, and that's probably against the law with the state of Washington as handing out gifts, would you think?
No, because they haven't put a policy in place. They did the research to do a policy, and that, you know, that's the heavy lifting, right? That's the work. But they haven't done an insurance policy, and so they haven't provided any benefit.
Oh, okay.
The more sort of interesting piece of this paragraph is the cancellation fees, because we all will go, oh, thanks for suggesting First American, but they suck, so I'm going to go with Next Title or Fidelity or whomever. Title companies have gotten out of that practice of charging cancellation fees
Yeah.
because it's a reason not to use them. The minute one company stopped charging them, the rest of them had to stay competitive. So this, who's on the hook for the cancellation fee, doesn't really come into play. But it could, if buyer and seller sign this document, they're agreeing to those terms, right? But the reality is, First American, in my example, isn't going to go, hey, Dick, you owe me $55. That's what they're
Right.
used to charge.
That's what I was getting at.
Yeah. Harry?
Well, it's not that much, the cancellation fee, I think it's $75, but it's, I always order the preliminary title to see what the seller doesn't know about his property, and you can address it while you're listing it, and then before it sells or closes, you can resolve a lot of headaches and problems.
For sure. That's a really smart practice, and unfortunately not everybody does that. You absolutely want to do it, A, because it's beneficial to you to have it stay with your favorite title company. And most agents are going to go, oh, it's already ordered, let's just go with that. But also it's beneficial to you and your client to know what's on there. If there's clouds on title, you want escrow to start working on them now. And your client may have to do some research to get documentation that helps escrow get rid of them. Okay? All right. Page 3 of 5, closing and possession. When is the buyer entitled to receive possession of the house on the closing date?
9 o'clock.
9 p.m. Can they get it sooner? Absolutely.
After it's recorded.
Yeah. Well, they can get even sooner than that if the seller agrees to it, right? Wouldn't be very smart.
I wouldn't.
Which is what going to Harry's like, that's blasphemy. What are you talking about? Right? There's liability if they gave possession before recording. Recordation is what moves it out of the Jones's name and into the Smith's name. And you don't want Jones there while it belongs to Smith, i.e. staying after closing, and you don't want Smith there while it still belongs to Jones, i.e. moving in before it closes. We get that issue a few times a year because we sell a lot of vacant houses, right, with REO. We'll have our weekly inspection and we'll see furniture in the house. Hey, what the hell's going on? Asset managers will cancel a contract over that because that is a huge mistake. And we've had agents in this office that didn't realize that and did that to a seller. So we want everyone to know you don't want to expose your client to that liability, period. Okay? Section 1031, like-kind exchanges. We can't do a 1031 exchange course in less than 8 hours, so I'm just going to read this one to you.
Okay.
All right? If either buyer or seller intends for this transaction to be part of a Section 1031 like-kind exchange, then the other party shall cooperate. That's the key piece of this, right? It's not the buyer's fault that the seller is trying to do a 1031, but the buyer, because of this paragraph, is obligated to sign the paperwork necessary for that seller to finish his 1031. Okay? Not a huge burden. And that's why they're saying, hey, let's get them to agree to that up front so that we can rely on their cooperation. If it changed the terms or did something weird, the buyer could just say, no, I don't want to do the deal, right? Because the seller would counter. If I had a 60-day window to sell my place in this 1031 exchange and I'm down the last 10 days, and Lacey submits an offer for her buyer to me with a 30-day closing, and I counter with a 10-day closing, because there's huge tax benefit to me of doing that. Her buyer can just say, oh, we can't close that fast, right? And it would be prudent for Lacey and my listing broker to talk and try and figure out a solution if there is one. If there's not, there's not. Okay?
I just have to ask a question because
Sure.
it occurred. So I just sold a house
Mm-hmm.
next door to me, and the buyer went out and looked at the property prior to closing and said, according to the terms of the contract, you're to maintain the yard in the condition that it was in when we purchased the property. Well, the seller, as soon as, he had an agreement with his maintenance people, as soon as the property was sold, don't come do my yard anymore.
Hold that question.
Okay.
We're going to get to that paragraph. Okay? All right. FERPTA. Does anyone know what FERPTA is? I just like saying it.
Federal International.
The closing agent, as instructed to prepare a certification, NWMLS Form 22E, or the equivalent, that seller is not a foreign person within the meaning of the Foreign Investment in Real Property Tax Act, FERPTA. So if I'm Chinese and I want to buy real estate in the U.S., I can, but the IRS wants to know about it. If I'm Chinese and I've owned real estate in the U.S., now I'm selling it, the IRS really wants to know about that, right? So there's a disclosure, and all parties are agreeing, when applicable, that we will help in the preparation of that form, right? The seller is a foreign person and this transaction is not otherwise exempt from FERPTA, closing agent is instructed to withhold and pay the required amount to the Internal Revenue Service. A lot of foreign nationals that own real estate here, if they notice that paragraph, might not sign, right? Or at least would think twice about it. But that just means they're trying to skirt their tax obligations. And so they end up getting the closing agent to help protect the IRS from that, protect us from that, right? Notice, in consideration of the license to use this and NWMLS companion forms, and for the benefit of the listing broker and the selling broker, as well as the orderly administration of the offer, counteroffer, or this agreement, the parties irrevocably agree that unless otherwise specified in this agreement, any notice required or permitted in or related to this agreement, including revocations of offers or counteroffers, must be in writing. Notices to seller must be, oh, I didn't attach it. Shoot. I want to make a very important point here, though. This paragraph is stating what's already in the law, right? No contract relating to real estate can be verbal. Did you know that? It has to be in writing. That's all they're saying here is, you know, notice has to be in writing, revocation has to be in writing. When is a contract considered received or notice considered to have been provided?
When you deliver it?
When it's
Signed.
received by the party that you're delivering it to.
Yeah.
That's why fax has been so popular. I mean, faxes are kind of going by the way of the buggy whip, but they gave you a timestamp on the form. Oh, you can see right across the top, oh, he got this at 8:58 p.m. or whatever, right? So it must be in writing. Now we'll go to page 4. Computation of time. Actually, you know what I'm going to do? It's a little blurry, but the part that got cut off says notices must be signed by at least one buyer and shall be deemed given only when the notice is received by the seller. That's the point I was just making. But signed by one buyer, that's a pretty important piece, right? Have you ever had a client say, well, my wife's, you know, getting her hair done and it's an inspection response, can't I just sign it? Now you know. The answer is yeah.
But they
No, this says they can. It's the continuation of this. Notices to seller must be signed by at least one buyer. Notices to buyer must be signed by at least one seller. Do you know what your context you're thinking of?
Well, I, just in the class, I don't know what in context, but just in the class, just from taking the class.
Yeah, an offer requires both,
Okay, maybe
but
that's
a
what I'm
notice
thinking.
does not.
Okay,
Yeah. Does that make sense to everybody else? 'Cause we just had a conversation and left out a bunch of words. If I write an offer, Mr. and Mrs. had better both sign. But then when I get my notice of lender consent, or I get my inspection response, or what, any of those subsequent notices can be signed by just one party, and they will be considered to have been received. All right? Now you could follow up and add the other person's signature later, but when the first signature was received by the other party, that's when they got notice. Okay?
I have to say then, if you are doing a mortgage and the lender looked at the documents, and they would be smart enough to know Washington state law only requires one signature on a notice, and it wouldn't cause an issue.
Yeah, I hope. How many loan officers do you think would go, wait a minute, I'm missing the spouse's signature? Probably a lot of them. But you're smart enough now to educate them and go, well, actually, technically, no, you don't need that. Right? Now, pick your battles, right? If you're dealing with a bank as an REO or whatever, and they're saying, I need it. I had one just yesterday. I submitted an offer to Chase for one of my buyers that said, Joe and Susie homebuyer, husband and wife. The asset manager said, you got to remove husband and wife. And it's because Washington is not a community property state. And I know that it is. You hopefully know that Washington is a community property state. But do I really want to convince Chase Bank that the guy, the attorney they paid $1,000 an hour to study Washington law, screwed up one of the basic tenets of Washington law? No. I just took off husband and wife. Yesterday they sent me an email saying, we need you to prepare an addendum that says Joe and Susie homebuyer, husband and wife. I'm like, awesome. So I did that. They said do it on a Form 34. So guess what I had my client do at the bottom of Form 34? I had them initial, because it says initial here. They rejected it. We need a full signature at the bottom of your Form 34. I'm like, you guys are killing me. It's just, pick your battles is my point, right? I can absolutely argue contract law with the best of them when it comes to real estate, but is it worth it, or should I just get their signature? And I did, much as it galled me. Okay, computation of time, this is a big one. Unless otherwise specified in this agreement, any period of time measured in days and stated in this agreement shall start on the day following the event commencing the period. Greatest example is mutual acceptance. We get mutual acceptance today. Day one of any and all of my contingencies is tomorrow. Does everyone get that? What if we get mutual acceptance today at 9:30 p.m.? Let's read on. Commencing the period and shall expire at 9 p.m. of the last calendar day of the specified period of time, except for the possession date. If the last day is a Saturday, Sunday, or legal holiday, the specified period of time shall expire on the next day that is not a Saturday, Sunday, or legal holiday. Any specified period of 5 days or less shall not include Saturdays, Sundays, or legal holidays. Ooh. So if I write, what's the difference in length of an inspection contingency that is 5 days long versus one that is 7 days long?
Nothing.
There is no difference, because the 5-day contingency does not include weekends, and the 7-day does. So if day one of my contingency is Wednesday and I have a 5-day, Thursday, Friday, Monday, Tuesday, Wednesday. If it's a 7-day, Thursday, Friday, Saturday, Sunday, Monday, Tuesday, Wednesday. I end up on the same day. So if you have a client that says, let's do a week-long inspection, write it for 5 days. I do this on every single offer I write. It makes it look more aggressive to the person reading it, right? All right. If the parties agree upon and attach legal description after this agreement is signed by the offeree and delivered to the offeror, then for the purposes of computing time, mutual acceptance shall be deemed to be on the date of delivery of an accepted offer or counteroffer rather than the date the legal description is attached. Time is of the essence. Make sense? Happens a lot, right? Legal gets attached a couple days later. Mutual is still the day that they agreed to all the terms. Back to my question about 9:30 p.m. Expires at 9 p.m. So if I get mutual tonight at 9:30, it's considered to have been mutualed tomorrow because it came in tonight. I used that to my advantage just last week because of the way the 4th of July was and the speed at which the listing agent wanted me to compress my inspection contingency. I said, okay, he wanted a 3-day. And I said, all right, I can do that, but I'm gonna send him ratified at 9:15. So day 1 was now the next day. I had a 3-day week. I had a 4-day weekend, right? Because 4th of July was on a Thursday. So my 3-day inspection actually ended up being 7 anyway. Does that make sense to everybody? So on Tuesday, I could have had ratified, but instead I sent it Tuesday at 9:15 p.m. It was considered to have been Wednesday. Day 1 of my 3-day contingency was the following Monday, Tuesday, Wednesday.
You write the time of ratification on there, or?
No, I just waited for the argument to come. Hey, your inspection was due yesterday, you're late. No, I'm not. Paul, in our office, Paul had this question of me just the other day. And I'm driving in the car. But I know this paragraph inside and out. And he said, they're squawking like I've only got, or they're squawking like he's representing the seller. They're squawking like they have another day and they don't. And I'm deciding whether I want to use that as leverage over them. What pops into my head immediately is agents that announce when their expiration dates are usually tend to be the agents that know this paragraph, right? So my first thought was, you should check and see, did you do the math? What did you come up with? And he said, well, I came up with tomorrow, or I came up with today. I'm messing up my own head. I came up with yesterday. They think they have today. And I said, what time did you receive it? And he said, why does that matter? He received it at 9:04 p.m. The agent was doing the math right and used a 4-minute loophole. So it can come into play. So you need to know it so that you can use it to your advantage. Okay? Make sense to everybody? I didn't say it very eloquently, but it's great stuff.
So
Yes.
if you are working with a savvy agent who
Mhm.
does know that last paragraph,
Yeah.
and they specifically say to you, you have to get this into me before 9 p.m. Does that ever happen?
Sure. They can say whatever they want.
Um,
And you'll hear this come out of my mouth often when people come to me with really radical requests from other agents. What does the contract say? Because ultimately that's what's going to prevail. Anything you do to meet that request is an accommodation, unless the contract says otherwise, right? He might say 9 o'clock because it expires at 9. So you want to deliver it by 9. He might say 9 o'clock because he's trying to keep the heat on you. That doesn't force you to do anything. Now, you guys have to decide, okay, am I worried about someone else swooping in and stealing this house? My client really wants it. I do want to move quickly to avoid that. That's why I started 4 minutes late here today, right? Because time is of the essence. Time is of the essence. We all use that, euphemistically. It's literal. The agent that tried to screw me out of the 3.5% commission sent me an email that they had sent to the MLS to adjust the SOC. That's irrelevant because time is of the essence. It's what it was when I submitted the offer. It has nothing to do with when they notified the MLS. It is relevant when the MLS updated it. That's one of the risks of an agent not updating their own listings, right? You're relying on a third party. Well, they're not going to do it immediately. You might be 50th in line, okay? Facsimile and email transmissions. Facsimile transmission of any signed original document and retransmission of any signed facsimile transmission shall be the same as delivery of an agent in the original. That's an important clause that's probably been in there for 15 years, right? When I first got in the business in 1987, the facsimile had just been invented. And I remember asking my boss, I'm like, how the hell did you guys do real estate without fax machines before? Well, we drove around, right? As technology evolves, the agreement has to evolve too. This paragraph didn't always say email transmission, right? Does everyone know the 22D where you can add an email for notice, right? In this office, it's office@millerlane.com. That's because of the evolution and advent of email, okay? At the request of either party or the closing agent, the parties will confirm facsimile transmitted signatures by signing an original document. So if the lender says, this is all fine and good, but we need wet signatures on something, you're agreeing up front as a buyer or seller to provide that at closing. But they're saying, let everyone kind of operate and move this thing towards closing ahead of that, okay? All right. And integration and electronic signatures. This agreement constitutes the entire understanding between the parties and supersedes all prior contemporaneous understandings and representations. No modification of this agreement shall be effective unless agreed in writing and signed by buyer and seller. Parties acknowledge that a signature in electronic form has the same legal effect and validity as a handwritten signature. Not all sellers accept e-signatures. REO is a great example. Short sales is another example. Negotiators always want wet signatures. Just be aware of what's legal and then be aware of what's prudent. Really, do you really want to stand your ground on, hey, you should accept electronic signatures when it's a short seller that's saying, no, the lien holder requires wet? Right? Assignment. Buyer may not assign this agreement or buyer's rights hereunder without the seller's prior written consent unless the parties indicate that assignment is permitted by the addition of, quote, and or assigns on the line identifying the buyer on the first page. Have we all seen that? Right? Diane Middaugh and or assigns. That's an announcement to the world, and in particular the seller, that she's reserving the right to move that contract to somebody else and hopefully take a little profit. You can't sell that without having made that disclosure, though. Now, what if Diane wrote that agreement just in her name, didn't put and or assigns, and then later decided that she wanted to assign it? Could she do that? She could if the seller agreed to it in writing.
Yeah,
Right?
but she couldn't do it on her own.
You're exactly right, Harry. So you would have to do a Form 34. Right? Buyer is intending to assign her rights to purchase 1234 Main Street. Seller agrees to allow this assignment to Joe and Mary homebuyer. Okay? Default. On Form 21, when we did that training, I said you should always check this box. Who remembers what box? Forfeiture of earnest money. Right? If I don't close, I'm the buyer and I don't close and all my contingencies have expired, you should get to keep my earnest money if you're the seller. right? Seller's election of remedies opens it up. Seller may, at seller's option, A, keep the earnest money as liquidated damages as the sole and exclusive remedy. So basically, even though you gave him that right, he could go with this forfeiture clause. Or B, bring suit against the buyer for seller's actual damages. Wow, that's a blank check, huh? Or C, bring suit to specifically enforce this agreement. Have you ever heard the term specific performance? The courts can force you to buy a house if the other party wins, right? D, pursue any other rights or remedies available to at law or equity. You don't hear about specific performance very often because most people check this box and the seller's signature at the bottom agrees that he's not going to go with that route. He doesn't have that option available to him any longer. He's agreed that liquidated damages are limited to the earnest money. That's a really important box to check, isn't it? I mean, there's some serious repercussions if you don't. Professional advice and attorney's fees. Buyer and seller are advised to seek counsel of an attorney and a certified public accountant to review the terms of this agreement. Buyer and seller agree to pay their own fees incurred for such review. However, if buyer or seller institutes suit against the other concerning this agreement, a prevailing party is entitled to reasonable attorney's fees and expenses. That's basically the MLS protecting us by putting language in that says, hey, you should get counsel from the appropriate parties as to how it affects you legally and financially. Because Lacey Ford is not qualified to opine on that, right? Neither am I, neither any of you. Offer. Buyer shall purchase the property under the terms and conditions of this agreement. Seller shall have until 9 p.m. on the offer expiration date to accept this offer, unless sooner withdrawn. Does anyone put language in that field just past the offer expiration date field? You know how there's a line there? I do.
Unless sooner withdrawn.
No, I put a different time of day. I put a different time of day because it's pretty rare that I want to give them till 9 p.m. So my default is 5 p.m. If I'm in a hot market and there's a lot of velocity, I might say it's due by noon. I want to give you 3 hours or from today till noon tomorrow because I want to keep pressure. Now remember, in previous trainings we've talked about the pre-offer conversation with the listing agent, right? I'm not trying to be adversarial. I am trying to find out what is the shortest amount of time that I can put on this offer that doesn't create a hardship for you, but still kind of keeps the ball moving, right? And I say it very convincingly and benefit rich, right? But my motive is I want to freeze out any competitors. 9 p.m.? What do you need the extra 4 hours after 5 p.m.? I know, when the buyer comes home from work, yada yada. But I've had a conversation with the listing agent. I know we can do this via email, we can do it by electronic signatures. I'm just going to do whatever I can to shorten that period. Okay? Acceptance shall not be effective until a signed copy is received by buyer, by selling broker, or at the licensed office of selling broker. So if I'm out showing houses and we wrote an offer yesterday and the listing agent shows up here and drops it off, it's considered received, right? At whatever time notice was delivered to the selling brokerage. Does that make sense? If this offer is not so accepted, it shall lapse and any earnest money shall be refunded to the buyer. That all makes sense to everybody? Okay. Counteroffer. Any change in the terms presented in an offer or counteroffer other than the insertion of the seller's name shall be considered a counteroffer. If a party makes a counteroffer, then the other party shall have until 9 p.m. on the counteroffer expiration date to accept that counteroffer unless sooner withdrawn. Acceptance shall not be effective until a signed copy is received by the seller, by listing broker, or at the licensed office of the listing broker. If it's not accepted, it'll lapse. Earnest money will be refunded. So you can take a contract, especially if you typed it, when it comes back, you have to scan all pages and see if there's anything handwritten that's changed it. If there is, you don't have mutual. Right? This one with the commission where they're trying to screw me over. They sent a contract. He had changed one date on the contract. We're in a little bit of an argument about commissions, and I'm betting that that agent doesn't know these rules. So I said in one email, I said, the good news is we're already ratified, so thanks. Your brokerage is already on the hook. That made him buckle. I was not right because he had initialed on page 8, right? But when you know more about the contracts than the other party, you can be more influential. Now, you might tell me you wouldn't feel comfortable making a misstatement like that. But I wanted to put the pressure on the seller because he's a tightwad, and I wanted to see if I could get him to come up. And he did. I don't like rewarding sellers that do that. It has nothing to do with the money. It's all about, hey, all my fellow agents are looking at this listing at 2%, going, do I really want to show that? So we grabbed it, but he offered 3.5. All right, how are we doing on time? Oh, 10 minutes, 5 minutes. Offer and counteroffer expiration. If no expiration date is specified, it'll expire in 2 days after it's delivered. Make sense? Agency disclosure. This paragraph replaces Form 42 for those of you that have been around for any period of time. We used to have a separate addendum to disclose who represented whom. Now it's just a paragraph in Form 21. Selling firm's designated broker, selling broker's branch manager, if any, and selling broker's managing broker, if any, represent the same party that selling broker represents. Listing firm, yada, 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 represents the same person the listing broker represents. If selling broker and listing broker are different persons affiliated with the same firm, then both buyer and seller confirm their consent to designated broker, branch manager, if any, and managing broker, if any, representing both parties as dual agents. Why is that sentence necessary?
For full disclosure purposes, so they understand that you're working for the same firm.
Technically, if Lacey writes an offer, I, as Lacey's designated broker, am representing that buyer, let's say, just as much as she is. So I have a duty to that buyer, just like Lacey does. Now, most of it is going to be carried out by Lacey, but if Lacey disappeared, went on vacation, didn't tell anybody, I have an obligation as her designated broker to fulfill those fiduciary duties, right? Well, what happens if her buyer falls in love with one of my REOs? I'm also the listing broker, and I have a duty to Freddie Mac or B of A or whomever. That's legal in this state. Dual agency is absolutely legal in this state. And it's not legal in all 50 states, so that's kind of a unique and cool opportunity. But it does require, when it occurs, that it be disclosed to all parties. That's why on Form 21, if you notice at the bottom, you check selling broker represents buyer, seller, neither, or both. That's why those check boxes are in there, so that you can overtly state, hey, I represent this party. Does that make sense? But we want language in the contract that gets buyer and seller to say, hey, I'm okay with that. That doesn't absolve our duties. And if we, share information with one party about the other, we've got negligence to worry about, right? So we have to protect the confidentiality, but you can have dual agency. And your best practice is to say nothing to either, right? If I'm, and not even in this example where really there's kind of an arm's length between me and Lacey, right? Legally there's not, because we're considered one and the same broker. But physically, she cannot tell me stuff that I might disclose to Freddie Mac in that example. But let's say I represent the Joneses on their house. and the Smiths come along and say, we want to buy it, we want to buy it through you because we think we can get a better deal if we just deal through the listing agent, right? We've all heard that. I can represent both the Smiths and the Joneses, but you know what box I'm going to check? On the listing line, I'm going to say I represent the seller. On the selling line, I'm going to say I represent the seller. Because I'm going to say nothing to either party, and I have a contractual, via the listing agreement, duty to the seller. I don't yet have a contractual duty to the buyer, and I'm going to check that box so I keep that in the same condition. And they're almost always going to be fine with that because they're hoping that that saves them money. Does that make sense to everybody? All right. We're almost to the end. Commission. Seller and buyer agree to pay a commission in accordance with any listing or commission agreement to which they are a party. Listing firm's commission shall be apportioned between the listing firm and the selling firm as specified in the listing. Seller and buyer hereby consent to listing or selling firm receiving compensation from more than one party. Seller and buyer hereby assign to listing firm and selling firm, as applicable, a portion of their funds in escrow, equal to such commissions, and irrevocably instruct the closing agent to disperse the commissions directly to the firms. That sounds confusing, but what it's saying is commissions go to Miller Lane Properties and then to you. And that's because in all the contracts, if Lacey had 10 listings and then decided to leave the brokerage, the listings actually belong to me as her designated broker. Now, obviously, she has a relationship with all 10 sellers, and she's going to talk to them first and say, hey, come with me. But she needs me to release them. Not that we want anyone to leave, but we tend to be very open. Because at the end of the day, if she stays in the business, I still want her to sell my listings. I'm going to have buyers that want to buy her listings, so we don't screw people on the way out the door. But legally, we have the right to keep those listings. And that we use that as leverage to make sure that we cooperate. There might be a referral agreement needed, or it could be a company-generated lead, or whatever. We want to make sure that everything just closes the way it should. Okay? Cancellation rights and lead-based paint. If a residential dwelling was built on the property prior to 1978, and the buyer receives a disclosure of information on lead-based paint and lead-based paint hazards, MLS Form 22J, after mutual acceptance, buyer may rescind this agreement up to any time up to 3 days thereafter. That's kind of interesting. So you write an offer representing the buyer, and you forget to put a 22J in your offer. That doesn't change the age of the house, though, does it? It's still built whenever it's built. You realize after the fact, hey, I forgot, there's no I didn't put a 22J in, but this home was built prior to 78. Please have your seller fill one out and send it to me. Because the seller has an obligation to disclose what they know. So you can compel them to provide that. And now you got 3 days to terminate if you want, because of this clause. In part, that's why most good agents will put a 22J that's already filled out in the attached docs, because now they've already delivered that disclosure, right? Plus it makes it easier for you to just put that in your offer. But this clause would allow that to play out the way I just described. The last paragraph. Information verification period and property condition disclaimer. Buyer shall have 10 days after mutual acceptance to verify all information provided from the seller or the listing firm related to the property. This contingency shall be deemed satisfied unless buyer gives notice identifying the materially inaccurate information within 10 days of mutual acceptance. Could I write an offer with no addenda at all? Just the Form 21 and terminate within 10 days? Kind of what that sounds like, huh? The only flaw with my theory is I have to not only give notice, but I have to identify the materially inaccurate information. So that only works if there was misinformation in the listing. But absolutely can work. In fact, I asked Justin Haig as counsel to the MLS, I asked him about that at a training once, and he said, you know, people used to invoke that clause a lot. It hasn't happened in a long time, and I think it's because people are getting better at making the listings more accurate. Right? If you were to terminate under that arrangement, earnest money shall be refunded to the buyer. Buyer and seller agree that except as provided in this agreement, all representations and information regarding the property and the transaction are solely from the seller or buyer and not from any broker. That insulates us, right? Your client can't scream at you because the MLS was wrong. Square footage is wrong, right? Parties acknowledge that the brokers are not responsible for assuring that the parties perform their obligations under this agreement, and that none of the brokers has agreed to independently investigate or confirm any matter related to this transaction except as stated in this agreement or in a separate writing signed by such broker. Law of agency, remember? It says that we don't have an obligation to investigate unless we agree to do that. That's what this is saying. In addition, brokers do not guarantee the value, quality, or condition of the property, and some properties may contain building materials, including siding, roofing, ceiling insulation, electrical, and plumbing that have been the subject of lawsuits and/or governmental inquiry because of possible defects or health hazards. What do you think they're talking about there? Asbestos. Yeah. Popcorn ceilings, asbestos siding, whatever. Would you want to be held liable for the building materials of a house? No way, right? That sounds to me like a lawsuit that was born of, well, I bought a blender and it didn't work and I returned it and got the salesman to replace it. Now I bought a house, I'm going to return it and get the salesman to replace it. No way. Okay? Some properties may have other defects arising after construction, such as drainage, leakage, pest, rot, and mold problems. Brokers do not have the expertise to identify or assess defective products, materials, or conditions. Buyer is urged to use due diligence to inspect the property to buyer satisfaction and to retain inspectors qualified to identify the presence of defective materials and evaluate the condition of the property, as there may be defects that may only be revealed by careful inspection. Buyers advised to investigate whether there is a sufficient water supply to meet buyer's needs. Buyer and seller acknowledge that home protection plan may be available, which may provide additional protection and benefit to buyer and seller. Brokers may assist the parties with locating and selecting third-party service providers such as inspectors or contractors, but brokers cannot guarantee or be responsible for the services provided by those third parties. The parties agree to exercise their own judgment and due diligence regarding third-party service providers. Piece of cake, right? Now, the condition clause that you were about to speak to, do you know what addendum that's in?
Something to do with lawn maintenance.
You asked a question about, you sold the house next door and you cut off the lawn maintenance and it looked like crap when you closed.
Yeah,
And I made you stop.
yeah.
The condition clause.
Yeah, as soon as the sign went up sold, the maintenance guy quit. But then we had the special added attraction of, it was a 30-day close and they wanted to extend that closing. And the last lawn work was done in time for a 30-day close. And they extended 2 more weeks, 3 by the time it was over with.
And
of
we're in
course
the
the
hot-
lawn had grown.
We're in the hot season and mix in a couple July rainstorms and lawns explode, right? 22D has a clause that will cover that says seller agrees to keep the property in the condition that you found it when you wrote your offer. So your seller had an obligation, and if the buyer's agent raised the stink, you should get the seller to send the lawnmower guy back out there,
Yeah.
right? Now, more often than not, the lawn's a little long, but this time of year, 2 weeks, man, it's more than a little long, right? It's so tall it's laying down now, and it looks like hell. So, that's a great example, Dick, because that's the call that isn't very fun, and it kind of makes you defensive. And if you don't know what your obligations are, you might bristle back and tell them to go stuff it, right? But you have a clause that your seller signed and agreed to that says you're gonna mow the lawn.
And I recognized that, but when the second extension came along, I said, look, this has cost the seller time, energy, and money. Now you want another extension. The seller doesn't have a problem with signing another extension, but he wants $500 to do it. Because we were basically out of
Did the
contract.
buyer say yes?
Pardon?
Did the buyer say yes?
Well, we told the buyer that was the terms, and we told
Sounds
the
like-
agent to write that up and get his buyer to sign it, and we'd go ahead and it didn't get done that way.
So the buyer didn't say yes.
I was being a little flip on it,
Yeah.
but
Hey, you don't get what you don't ask for, right?
yeah.
But
I
you
told
also
him-
are days away from closing and getting $500,000. And so are you gonna, as a seller, are you gonna, tell that buyer to go screw off? Probably not. But I said it earlier, we don't ever get walked over, but you have to pick and choose when it's time to really bow your neck. And that's probably not the time, because you had a contractual duty to mow it anyway, right?
But we were out of contract.
Well, then you don't have a deal.
You say that like it's a badge of honor. You should never have let it get out of contract.
It got out of contract just like that.
Right. So your seller's just at risk as the buyer.
Well, I informed.
Both agents,
Yeah.
right? And I'm not picking
No.
on you, but that's not a defense, right? And it's not a leverage point with the buyer. Hey, unless the buyer wants it more than your seller wants to sell it.